So today we will talk about homicide offenses and criminal law. First of all, before we move to homicide offenses, I would like to introduce myself. I'm Nini. I'm founder of Simple Studying. I have LLB and LLM degrees from City University of London. I've got high to 1 and first class grades in my assessments in law school. And then I built Simple Studying to help other law students as well have the same success as I had. We are a team of successful law graduates who have built this platform. Now we are expanding. We're building an all-in-one platform for UK and US university students to get high grades and build successful careers. Why you should trust us. We have over 25,000 registered customers, mainly for law degrees in the UK. That's like 25% of total law students in the UK. 90% of our regular customers have reported to have got a first class. And after working with thousands of law students, we know exactly how to get high grades as evidenced by the reviews that we have. So homicide offenses. There are three main types of homicide offenses that you have to know. This problem question or essay question about homicide offenses most likely will come up on your criminal law exam. So that is why I have chosen this topic. It's a very, very common topic on criminal law exams, and it's very important for you to know how to draft an answer to a problem question or an essay question about this. Most likely it will be a problem question because most of the times they have a problem question about this topic, but it could be an essay question as well. Murder, voluntary manslaughter, and involuntary manslaughter. Now, let's talk about murder specifically. For every criminal law offense, when you start discussion in a problem question, you have to first say what is actus reus and what is mens rea of that specific offense. So actus reus is the physical element of the crime and mens rea is the mental element of the crime. Every single criminal offense has an actus reus and has a mens rea, and murder is no exception. So actus reus of murder is any conduct that causes the death of a person, unlawful killing. Whereas mens rea of murder is intention to kill or cause grievous bodily harm, so serious bodily harm. How to answer a problem question on homicide offenses. It's very important to start by defining what is the actus reus of murder that I just stated. Then you have to apply the facts and provide analysis. You have to say whether or not actus reus of murder, according to the facts of the case that you've been given, was satisfied. And cite relevant cases such as Gibbons and Proctor can be cited for actus reus, but depends on the circumstances of the problem question you're dealing with. You may have to cite another case. The case you cite has to be relevant in terms of the facts, like it has to be factually similar to the problem question that you're dealing with, or it has to be relevant in principle. So the principle, like the actus reus of murder you're referring to, has to be coming from that case that you cite. Then define mens rea of murder, which is intention to kill or cause serious bodily harm, and apply it to the facts of the case and provide analysis in your problem question answer. Did the defendant have an intention to kill or cause GBH? Cite relevant cases like Cunningham is a key case in this area. If there is no direct intention to kill or cause GBH, maybe there is oblique intention. You need to know the difference between direct intention and oblique intention. What's the difference? So now, defendant has the intention to kill or cause GBH where they have committed an act or a mission to bring about the result, the direct intention. Defendant's act or omission is virtually certain to cause that result, that defendant foresees it as a virtual certainty. So if it's a virtual certainty, then it's oblique intention. If the defendant intended to kill or cause GBH, then it's direct intention. You should have a look at cases of Cunningham, Hayam, Maloney, Woollin, and Hancock. We have case summaries of all these cases on our platform. So if you go to simplestudying.com, you just search any of these cases, you'll find the case summary. it's available for free. So I suggest that you cite the case that is not only relevant in principle, but also factually most similar to the problem question that you're dealing with. So you have to look at both facts and principle that came out of this case and cite the cases that are the most relevant to the argument that you're trying to make in the problem question. After discussing direct and oblique intention, there is no one correct answer in law, so you can never say for sure if defendant had direct or oblique intention. So your objective here is not to say for sure if it was an direct intention or oblique intention. The only thing you have to do is define what is direct intention, define what is oblique intention, cite relevant cases, and provide analysis. You cannot possibly say for sure if it was direct or oblique intention. That's not how law works. You're supposed to provide arguments on both sides, possible answers rather than one answer, because it's not science, it's not math. Law has many possible answers. So proceed to discuss the next possible offenses after you have exhausted your arguments for direct and oblique intention. The next possible offenses would be voluntary manslaughter and involuntary manslaughter. So first you discuss murder, then you discuss voluntary manslaughter, and finally you discuss involuntary manslaughter and then defenses. So voluntary manslaughter, this is when there is actus reus of murder, but there is mens rea as well, but one of those partial defenses apply. So you have actus reus and mens rea of murder, but partial defenses apply. The three acceptable partial defenses for voluntary manslaughter are loss of self-control, diminished responsibility, and suicide pact. Loss of self-control when someone is out of control, fear of serious violence, seriously grave circumstances that justify the act of killing. It is important to note that jealousy does not count as loss of self-control. So the case, if there is any case where the reason for losing self-control was infidelity, that will not be enough to satisfy loss of self-control threshold. Second, diminished responsibility. This is when someone has a medical condition that substantially impairs their mental capacity to make a sound judgment. And finally, suicide pact, when the defendant and victim had an agreement to commit a suicide together, and then one of them did not. Involuntary manslaughter, unlike voluntary manslaughter, here the mens rea of murder is not present. There is actus reus of murder, but mens rea of murder is not present. So it's like it was an accident, basically. The killing of a person was an accident, a result of either an unlawful act, gross negligence, or recklessness. So, for example, if someone died in a car accident, that could be unlawful act manslaughter rather than murder, because yes, there is actus reus of murder, but there is no mens rea of murder, intention to kill or cause GBH. That is not present. Whereas unlawful act can be reckless driving, negligent driving, that can be unlawful act that will then lead to the conviction of unlawful act manslaughter. Gross negligence is usually in medical cases when doctor was grossly negligent, as a result, patient died. Reckless manslaughter when someone committed something very, very reckless, and as a result, someone dies. So involuntary manslaughter, actus reus of murder is present, but there is no mens rea of murder. These are the three, for the unlawful act manslaughter, these are the requirements. First, there has to be some kind of unlawful act, which is the base offense. It can be negligent driving or like any kind of unlawful acts, any act that is not legal. Then this act has to be objectively dangerous. So if it's something very, very unlikely happened, which was not the result of an unlawful act committed by the defendant, then it would not be unlawful act manslaughter. It has to be unlawful act and something very, very dangerous. For example, drink driving. So when someone drinks and drives, that's unlawful and also dangerous. So that fits the requirements. Finally, it has to cause death. And mens rea, establish the mens rea of the unlawful act. Unlawful act manslaughter receives a lesser sentence. Murder, you have life sentence, whereas unlawful act manslaughter has lesser sentence than murder. Gross negligence manslaughter. This is when there is a duty of care. Defendant owed victim a duty of care. You probably remember duty of care from tort law if you've studied it. This is basically when defendant has some kind of duty to act. It can be doctor-patient relationship. Doctors always have duty of care to their patients. Defendant then breaches that duty of care. The breach caused victim's death, and defendant was grossly negligent. So duty of care, breach of duty, causation, and negligence. It's very similar to tort law, but this is about killing of a person as a result of gross negligence. Example, Adomako. This is a case where doctor failed to notice that a tube supplying oxygen to the victim was detached. Since the oxygen was not flowing anymore, victim died, and as a result, defendant was convicted of gross negligence manslaughter. Reckless manslaughter, defendant caused the victim's death as defendant reckless as to causing death of grievous bodily harm. So causing death and recklessness as to causing death or grievous bodily harm are the requirements of this offense. Also, very importantly, there must be foreseeability. So defendant foresees high risk of causing death or GBH. And the sentence defendant receives here is usually higher than gross negligence or unlawful act because there is this foreseeability element present here. You have to discuss general defenses at the end. General defenses are applicable to all kinds of criminal offenses, not just to murder, but you have to always discuss general defenses. For every single criminal law problem question you have, final point should be general defenses. These are full defenses. So if any of these defenses apply, the defendant can be acquitted. So the defendant doesn't go to jail if these defenses apply. One of this, so this is the conviction. Actus reus plus mens rea minus defenses equals to conviction. But if actus reus plus mens rea plus defense is present, then no conviction. Automatism is one of the full defenses. Defendant's conduct was involuntary, unable to control. Example is Broom versus Perkins, where defendant was diabetic and lost control of his body when driving. The defense failed because defendant had exercised conscious control over his car. So if for whatever reason, whether it's a medical condition or something else, the defendant loses control of their bodily actions, that can be relevant for automatism defense can apply. But very important, it has to be total loss of voluntary control. So if there is any evidence that defendant had some control of their body during the act, automatism defense will not apply. It has to be total loss of voluntary control. Insanity, very famous defense. This is when the defendant is insane. All individuals are presumed to be sane, but the burden of proof to prove insanity, if relevant, is on the defense. Usually, the criminal offenses burden of proof is on prosecution. But for proving this defense, insanity defense, it's on the defense. The details, the requirements of this insanity defense is set out in the case of Nathan. Duress, another full defense. Duress by threat. Defendant commits a crime due to threat by a person that defendant or someone else will be killed or seriously harmed. So if someone committed a crime as a result of a threat, then it could be relevant for duress to be set to be discussed by the defense. Duress of circumstances. This is similar to duress, where defendant is not threatened by a person, but is threatened by circumstances. And duress is a common law defense. It's not set out in a legislation. Private and public defenses, self-defense. Private is the one where you protect yourself. Common law defense, also set out in Section 76 of the Criminal Justice and Immigration Act 2008. Public is when defendant is acting in prevention of a crime or making arrests. Section 3 of the Criminal Law Act 1967, also set out in Section 76 of the Criminal Justice and Immigration Act 2008. For more information about MADA or any other topic in criminal law, you can check out simplesenate.com and just search criminal law there, or you can just scan this and you will be taken to a criminal law page straight away.